Okay, so thank you, everybody. Welcome to the Litigation Center's The Role of Technology in Jury Trial, produced and presented by Dustin Cameron. My name's Rachel Brockel. I'm the director of the litigation program. I am recovering from an injury, so I want to thank my litigation center TA, Greg Russo, who's in the room, who's been doing everything physically on campus and behind the scenes, and then Christina Robinson, our student Baxter Fellow as well, for assisting in getting everything up and running in the room that you're seeing right now. As you know, that there is some Chipotle in the room, so feel free to grab snacks, grab some drinks, and get situated for the event. It should be a good one. If you're an attorney in the room, there is California MCLE provided. That's whether you're on Zoom or in the classroom. Please message me after this event if you are on Zoom so that we can send you the MCLE certification form. And if you're in the room, please sign the certificate that's in there that is a roll of attendance so that we know that you were there. And then we will email you a certificate of attendance as well. If you're a student, especially if you're in my intro class or you're in a mock trial course, please sign the form that's in the room as well. That way we know who attended, and you can get also credit for attending if that's something that was offered in your class. If you're online, I will go through the roll of attendance after the event gets started in just a few minutes here, and I'll write your name down as you were there in attendance. Dustin Cameron, our guest speaker for today. I want to welcome and thank him for being here. He does a lot for the Litigation Center. I met him through the Litigation Center. We both went to school at GGU. We both graduated. He was a Baxter Fellow part-time, and he's come back and helped us in so many different ways. I know he's really passionate about trial work, so I know this is going to be a really, really great event. So Dustin, thank you for being here. And now Gregory Russo, who's our Litigation Center TA, is going to read Dustin's bio for us, and then we'll get the event started. So thanks again, Dustin, for being here.
Thanks, Rachel.
Dustin Cameron currently works at Cogent Legal.
Oh, we need the microphone.
Thank you. Pass the hot mic.
All right, that's better. Dustin Cameron currently works at Cogent Legal as an attorney consultant. Prior to joining the Cogent team, Dustin was a practicing litigator, handling business disputes, product defect, and high-value personal injury cases. Dustin tailored his career to trial work with an emphasis on case presentation and persuasion. Dustin now assists attorneys as a trial and jury consultant and is heavily involved with case strategy throughout each phase of litigation. Prior to becoming an attorney, he graduated from GGU Law, where he contributed to the Litigation Center as a Baxter Fellow by drafting In Vino Veritas National Trial Competition fact patterns, and through the mock trial team, where he now coaches students to competition. We welcome Dustin and look forward to hearing about the best ways to utilize technology during jury trials. Thank you so much. I really appreciate it. For all my folks online, if I am yelling at you, please let me know, because I have no idea what I sound like on your end. So if it's a little too high, I'll lower the microphone. I'll try my best to keep this handy, but I do like to walk a lot. Thank you again for having me come and present. I'm really excited about today's presentation. It's one that, frankly, a lot more attorneys need to know about technology in the courtroom. I know that all of you practicing attorneys and law students have seen attorneys fumble with paper, Elmos, all of the like during jury trials. It's a mess. It's disgusting. I don't like seeing it. I want to train attorneys how to best use technology in the courtroom to make sure that their presentation is running smoothly, but is also persuasive. That is always the goal. So what I'm going to show you real quickly is I'm going to do a little just tidbit. I want you to imagine that you are all jurors right now, okay? And I come up to you and I'm presenting a case on the plaintiff's side. I say, good morning, members of the jury. On March 16th of 2021, my client was crossing Market Street. And during that time, he looked left, saw no one was coming. He looked up and he saw that the crosswalk had changed the symbol so he could cross the street. He started to cross, and all of a sudden he was hit by a car, breaking his ankle and shattering his spine. Good? Pretty good, right? Okay, now what if I just go ahead and let's see if I can get technology going, and I have a nice little video where I can just press play and I can talk through this entire thing. I got you to visualize it with my words, right? But now I'm actually showing you a security video where I can show you my client is right there, Williams. He's going to go ahead and he's looking left just to check and make sure that no one is coming, because we know how San Francisco streets can be. And all of a sudden, he sees the light turns green for pedestrians. So he proceeds to cross and go through. All of a sudden, he is hit by a taxi cab due to the negligence of a driver. Okay. Now you see how when you actually are using animations, videos, and really calling out certain things, it has an emphasis. It has that wow moment that you all just had. And that is the goal of your first opening statement. Okay. That's always the goal. You want to wow the jury, or you want to explain why your client was not negligent in a way that is persuasive. And you want to use visuals to be able to show how the accident occurred, or alternatively, what your defense is, right? Rachel may have mentioned that I was a defense attorney for about 5 years. I was also a plaintiff's attorney before that. So I've seen both sides, and at Cogent Legal, we actually represent both the defense and the plaintiffs. We don't pick and choose. We see a good case, we jump on it. We like to do this work and help attorneys, okay? I'm gonna cruise on through this, and I apologize for the glare, guys. But you can see that you can actually embed medical images explaining exactly what the injury was in relation to the video. Okay, so now I want to just give you some stats, because no presentation is good unless it has some statistics in there, right? Percentage of people that are visual learners, okay? 65%. That is huge, huge. 35% are just readers, can read material and understand it, or doers. They need to get up and actually be present and do the thing in order to learn, okay? 65%. That means that when you have 12 people in the jury, 65% of that is a visual learner. So if you just get up there and talk and tell them a story, you're not doing your client any service whatsoever, okay? Second graph over here, visual data. That means that information that we receive and how we transmit it to our brain to understand it, 90% is visual. 90%. And then a small little 10% is all your other senses. Okay. Hearing, smelling, right? All of that. Okay. I say this because a lot of people think that we can just talk and talk and talk, and the jury is going to listen and listen and listen. But it's better if I can actually show something while I'm talking that emphasizes my point. Okay, top 10 tips. Shut up, Suri. Top 10 tips for PowerPoint, and I broke the rule already with this slide. I will tell you right now. First off, though, use PowerPoint to aid your argument. Don't use it as a script whatsoever, please. I see a lot of attorneys where they want to use heavy text and throw pleadings in there and arguments. And I'm like, no, that is what you verbally say to them. You need to actually show them something that corresponds with your argument. Consistency is key. Pick a background, color scheme, and stick to it. Please do not Frankenstein PowerPoints. That's my biggest tidbit of today. I've seen attorneys where I have themes that are, black and red, for instance, and then all of a sudden it shifts to white. I'm like, where'd we go? Where's the white, or where's the black, right? And then they have blue thrown in there, or orange, and all these crazy colors. It looks like a mess. You want your PowerPoint to actually look consistent. So for instance, I've got the nice little gray background right there, and you'll see that I've got blue font that's scattered throughout it, okay? Oh, color scheme. Let's talk about color scheme real quick. Defense attorneys, generally you want your colors to be actually calming to the jury, okay? Because the plaintiff's gonna get up there, they're gonna show you that horrible accident that we just watched, right? And you wanna be able to get up there and calm and soothe them the entire time. So we stick to a lot of blues, a lot of light grays, so and the like. Plaintiffs, depending on the case is what I would say. You want a little bit more umph in your colors. Usually there's a little bit of red, some oranges. I've even thrown greens in there occasionally, okay? But you want colors that are going to invite emotion, especially if you're going for punitive damages, okay? Oh, less is more when it comes to text. I am a horrible person where I use bold a lot, but it's because it pops all the time. I do tend to stay away from italics in PowerPoint because it just doesn't come across, as you can see over there. Underline is fine, but bold really actually gives you the umph the entire time. Don't yell at your audience. By that, I mean all caps. Every single one of us, I imagine, has had that parent, grandma, family member that just got their iPhone and all of a sudden you're like, why are you yelling at me, grandma? Yes, I'll pick up the milk. Come on, right? Same thing here. I've literally been in the courtroom where jurors have come back and said, yes, your argument was really good, but I couldn't get over the fact that I felt like you were screaming at me through your PowerPoint because everything was caps. It's the smallest thing, but anybody that has taken trial advocacy, members of the jury, you got members of the BART community, right? Not the brightest, not the sharpest tools in the shed normally, but at the end of the day, they're the one deciding your case. So you got to do whatever they like, okay? Use black screen. So if you have a clicker just like this, hopefully everyone on Zoom can see me. There's usually a nice little button where I can just go ahead and hit that. Oh, you're not going to like me. Okay. Hit a button. Doing presentation on trial or on technology, and we're going to have technology problems. Watch. There we go. Oh, this clicker doesn't like me. Okay, well, normally you have a little button up here that shows a black screen. You can also just actually hit Control B on the keypad over here. It'll shift to a black screen. So whenever you are talking and you don't have necessarily a visual to use, go ahead and just hit that black screen. That way it shifts the jury's attention back to you and what your argument is, okay? I know this is a lot of information. I'm going really, really quickly, but I have a lot of slides to get through. So I'm speaking really fast. I apologize and feel free to ask questions along the way. Hopefully my folks on Zoom will be tracking them. Use humor sparingly. It can easily backfire, especially to jurors. I try to avoid quoting people, especially famous people. One time I had an attorney that quoted Oprah during a trial. And one of the jurors came back and was like, you know, I would have found for you, but you quoted Oprah and I just hated her. Like, of all things, right? I just avoid quoting people. I have tried to avoid humor unless I know it's going to land with my jury. There's nothing worse than telling a joke and everyone's just like staring at you blank face, like, I hate being here. I have to be here. This sucks, right? Of course, you want to make trial fun and you want to actually connect with your jury, and telling jokes is a great way to bond with your jury. Just don't tell a bad one. That's the best advice I can give. Practice before presenting a lot. And when I say practice, I don't mean just clicking through your PowerPoint and talking to yourself out loud. I mean actually getting up, putting your PowerPoint up on a screen and actually clicking through it as if you were presenting to the jury, because you want to understand your technology and how it works. Courtrooms are not equipped, besides San Mateo, I will say. Courthouses are not equipped with IT folk to come and fix attorneys' presentations, right? So when you are in the room by yourself or with a paralegal, you better know how to fix it yourself. That's the reality. Avoid using distracting animations or transitions, anything that's flying in or zooming. It takes away from the actual presentation entirely. I tend to stick to the animation of fade. That's it. Very simple, just fades in and out, gone, okay? I've seen some crazy zingers where it's like flying all around the entire slide and the jury's like sitting there getting dizzy watching the entire thing go, okay? And this was my rule that I just broke. And you'll notice that I don't call it a rule. The 5-5-5 goal is what I call it. It is the most broken rule in the entire history of technology. You want to try to limit your slides to no more than 5 words per line of text, 5 lines of text per slide, or 5 text-heavy slides in a row. That's very difficult in law, as you can all imagine, because what do we have when we're presenting to a jury? Jury instructions that are long and really annoying to read out loud. When I am presenting jury instructions, normally what I'll do is I'll have the entire instruction there, but I'll call out the certain words that I want to see. So for instance, you've got a negligence case, right? And we're talking about duty or causation, right? I'm going to call out those key phrases that I'm going to argue to the jury the entire time, and I'm going to highlight them so that their focus is on those words and not the rest of the text that's on the screen. Does that make sense to everybody? Okay, moving right along. If my clicker works. Okay. So I've tried to break this down as best as possible in terms of what kind of graphics, technology, animations you can use for various cases. So the first one we're going to be talking about is personal injury. One of the key focus in personal injury cases, we're talking about premise liability, negligence cases, right? Medical malpractice even sometimes. The first point, though, is usually we're going to be doing scene recreation, right? Especially with car accidents, especially in San Francisco. There's a couple ways that we can do scene recreation. See if my clicker works again. Oh, there we go. So what you're going to see here is actually a drone scan of a highway, okay? We can actually fly up a drone and get an aerial view, and we can show damn near about everything, pardon my French. And you'll see that you can actually blur out anything you don't want to show, which is the best thing. I can have the jury focus on a specific strip of road that we were talking about, or businesses that we can talk about, whatever I want. I can really do a lot with drone scannings. My next one is going to be laser scanning. Laser scanning. Does anybody know what laser scanning is in here? I know you do, Rob. No? Okay, so in PI world, you're going to run into a lot of what are called usually accident reconstructionists, and they're experts, right? The first thing they're going to want to do is they're going to say, hey, I got to go do a laser scan of the entire, scene. What that does is it's just a tiny little device, a couple devices that you're going to set out in a nice little array, and it's going to take basically points of the entire area around. It'll take little trees, it'll take buildings, it'll take signs. It'll literally recreate all of that. And this is basically the raw data that you would get from that drone scan, and then you can clean it up to create an animation or graphic, however you want. Now you see here what basically just happened is it highlighted all of the shrubbery and the posts just now. And that is from Point Cloud. Now we're going to take away that grainy background right there. We can see the actual roads. And now we can actually recreate. And this is actually going to, I think, nope, it's not yet. So this was a case where we had a car accident. You can see, let's see, right there. Got that little car right there. One of the things that we will touch on a little bit later is talking about lighting, which is a huge issue. If you've got a case that is, happens at night, for instance, okay, it would be inaccurate for me to show a animation or recreation or a graphic showing it in daytime, just because it's lighter, right? And one of the key things that we do at Cogent Legal is we actually try to match the lighting so that it shows exactly how it was that night. Takes a lot of work, but we can do it. This is going to be from a personal injury case. Actually, we did a couple years back. This man, he was a worker, and he basically where this fenced off area is right here, it wasn't fenced at the time. And he accidentally stepped off the ledge and fell, I want to say it was like 10 stories and survived. It was a massive case. We had to actually show this little barrier right here, how it was supposed to be set up versus what it was during the day, which we had photographs to prove that, but we wanted to show how it should have been set up to show the company was negligent, right? This is where I'm talking about lighting right here. This was a FedEx case. It was a accident that actually happened. Thought it was an animation. We had a truck that was passing this FedEx truck, and he actually ended up hitting a guy that stepped out of here. Lighting is key in a lot of personal injury cases. I cannot tell you how many times I get a case and I'm like, okay, what time of day was it? That's my first question, right? How is the lighting? We've got to recreate this so that we can actually see what the driver saw if I'm defending, right? Or to see what the plaintiff saw at the time, okay? We can also do 3D modeling. 3D modeling is critical for cases that are involving heavy machinery or how a machine breaks down, for instance. This was one we did for Jelly Belly sugar silo. You can see right here, we've got this nice little man to show kind of the comparison of the size. And we can show the innards of the entire silo right here and the equipment. If my memory serves, I think this was a case where the guy actually got injured from fixing the motor. I think he actually lost a hand somehow, if I remember correctly. Okay. Similarly, right, we're talking about cars and mechanical failures with cars. I get up in front of a jury and I say, yeah, there was a mechanical failure with this, Ford Lincoln Town Car. Okay. But how am I going to be able to explain that to the jury? How am I going to be able to convey that properly besides showing it? I can't take the jury to the car and, strip it up and bring the car into the courtroom, right? So we got to do something else that's a little fancier. This was a case where the front coil suspension system actually went out, and I'm pretty sure the car flipped after it. Let's see here. This is exceptionally important when we are dealing with roofing, construction, anything of the like. We get a lot of cases that are construction accidents, essentially, where a worker is injured on a construction site while he's working. This is huge, and funny enough, there's a nice little Safeway Fresh and Easy, which Rob Bodson right here and I had too much fun defending a couple of companies similar to Safeway, we'll just say. But what we did here is we were actually showing a shopping plaza. And if I remember correctly, there was a man that was electrocuted in that shopping plaza. So we were trying to show kind of the innards of it the entire time. Maps. Has anybody here seen a traffic collision report? I know you have, Rob. Okay. Look one up online when you get a chance. They are, if you are going to go into civil, even criminal, you're going to be reading a lot of traffic collision reports no matter what. It's always saying P1 hit P2, V1, V2. It's a mess and it's hard to figure out. And usually they have a nice little diagram that's on the back that's a mess as well. What we can do is we can actually take those diagrams and we can show critical things. So in this case, we wanted to show the signs. We've got a nice little call out to the signs showing exactly where the signs were the entire time. These are helpful for usually traffic accidents, I would say. Sometimes if it's pedestrian versus car, usually helpful as well. So we can show crosswalks and all of the like, okay? Construction, we talked a little bit about construction, but we're going to talk a little bit more. So this is actually one of my favorites where we've got a little bit of a timeline element over to the left-hand side right here, where we're going to be going through these critical dates right here. You'll see that this is actually a map right here. If I had the full PowerPoint, what you would be able to do is you would actually be able to click that back to main map portion right there, and it would go back to this main map, and you could click into this map wherever you wanted, and it would show exactly whatever that slide was showing. This slide, for instance, is showing, April 12th, 2013, a nice little pipe underneath that looks like it is broken. We do a lot of what are basically interactive PowerPoints where you can click into a map or you can click into a specific timeline, right? And it's going to show exactly what you want as you go through it. This is just going through and showing the rest of the underground right here. And similarly, you'll see that we have kind of a similar setup on this slide. This was a construction defect case dealing with a nice little mansion right here. What you are looking at up here is the section of the house and where we are at. And then this is the picture corresponding with that section. Okay, so when we cycle through, we move up here to the upper section and we can show all this information right here and now, and I can explain it in my argument. I'm gonna cycle through these suckers. Love this graphic simply because it's simple and easy, right? That is the best kind of graphic. I don't need a bunch of information crammed onto a slide when I'm trying to present. These previous graphics we were just talking about, that's a lot of information to have on one slide, frankly, right? We've got the map over here. We've got the picture right here. We've got some text down here that we're talking about. And then we've got the actual diagram of the building down here, just showing a little outline of it, right? Still a lot of information to talk about, okay? when we just have a simple graphic where we can just say, okay, these are the spots right over here where all of the leaks were happening. That's easy. Everyone understands it. There's no need to explain whatsoever. I can literally throw this up right now and you know what it's about, right? My personal favorite is timelines. Every single case could use a timeline. And I'm not kidding you. Every single case could use a timeline. Fun, quick war story. I actually served on a jury as an attorney in my hometown of El Dorado County. Still don't know how I got on. I think they just lost and didn't have enough peremptory challenges, frankly. But I was sitting on the jury. It was a workers' compensation fraud case, not the sexy kind of fraud either. It wasn't like, oh, we're going to have a security camera of a plaintiff that's walking over and he sees a puddle and he's like, I'm going to fall, right? It was a company that was alleged that they were essentially fraudulently transferring employees to a different construction company in order to avoid premium charges. Very strange. My nitpick about this entire case. They got up an opening, they told us all these different facts. This is a document heavy case, right? We're talking about emails, correspondence with the insurance company, policy dates, all these things. And they're just telling us this information. I'm sitting there with my notepad, frantically trying to scramble everything down to try to take it down. They didn't use any sort of a timeline, okay? And I'll come back to that case in a second because it's it's got a couple of good points for attorneys. This was a very interesting one that we did. This was basically just showing blood pressure for a plaintiff and how it was changing. That was a central issue in the case for some reason. I don't know the backstory behind this one, so I can't give you more information. I wish I could. This is my personal favorite, though. This is what I would refer to as a symptom timeline, okay? It's showing each corresponding symptom, right? We've got dizziness, and we can show the dates that dizziness happens. That is actually a really good one for the plaintiff, of course, because you got to show when your client was having these certain symptoms, if that is an issue. But better for the defense, okay? Especially in TBI cases where you're dealing with a traumatic brain injury, you got a guy coming in saying, oh, I've got headaches this day. Oh, I'm dizzy this day, right? Showing the inconsistencies in the symptoms is a key thing that defense usually does at trial, especially with TBI cases. And I think if you'll see over here, this one actually was for the defense, where we are talking about, no blurry vision, no visual field loss on June 12th, 2014. Business timelines. These ones I tend to not like as much just because they're usually a little bit text heavy, right? There's a lot of information that we're trying to convey. Normally, I would have, each of these separate boxes slide in as I'm going through and talking about it. Now, when you've got that many data points that you're going to be talking about, that's a lot to go through, okay? Simple is better, okay? We will do whatever the attorney tells us to do, of course, but we will tell them simple is better. If I could, I would take this thing down to about 10, 15 maybe, okay? Just to make those major points. But for instance, mandatory settlement conference, we don't really need that. That's boring. This one is a fan favorite among the plaintiffs bar, I would say. These are just showing a medical treatment history. We will generally use little icons describing whatever the injury is. Usually it's a cervical kind of injury or a low back injury, whatever it is. But we can actually take information from the medical record. So we've got the actual incident date here. And then he goes to the ER. He has, complaints of vomiting, low back pain, neck pain, what have you. This is an excellent way to walk the jury through in opening statements what the treatment history was to show that your client was consistently treating the entire time. He's not faking it, right? For the defense, if you can show a lack of treatment, that's excellent, right? So if I've got treatment right all here before the accident, right? And I've got from here all the way to 2011, no treatment whatsoever. Oh, and then in 2011 over here, the lawsuit was filed. And guess what? And he starts treating all of a sudden, right? Beautiful and very effective, especially to a jury. I said that the symptom timeline was my favorite. This is actually my favorite, I think. Alcohol charts. If you have a case that's involving a DUI, so let me actually ask, how many of you plan to go into criminal, whether it be, PD or DA? Anybody here? 3 of you. You're gonna be doing a lot of DUI cases, okay? Not that the DA or the PD can afford us, but you should think about this. Using a chart to actually show the level of drinking and where the blood alcohol was at a given time. Beautifully done, very effective. This one actually got punitive damages of multiple $1 million just because it was so simple and easy to follow. There was a major issue in that case where no one knew what the blood alcohol was necessarily, but we could actually trace it back based off of the testimony about how many drinks he had, the alcohol content. It's very easy calculation, surprisingly. This one, again, a little bit of text heavy. This was a PG&E fire that we did where we were basically showing what PG&E knew at a given time. A little text heavy, but when you're dealing with large cases, class actions, any sort of complex litigation, usually you're going to have a lot of text, unfortunately. Oh, okay. This is the fun part. Now we're going to get to animation. So animations are a little bit different. There's a difference between a recreation and an animation. Okay, a recreation is where we are trying to recreate the scene exactly how it occurred. Very difficult, you can imagine, right? There's inconsistent statements. There's different versions of the events from different parties. It's a little bit hard. Usually you need a lot of data. Usually you need black box, for instance, from a vehicle, so you can actually show how the vehicle moved. But animations are very, very powerful because you almost get to put the jury into a movie, essentially, and tell them via a movie how this accident happened. And better yet, you get to put them in the point of view. Anybody who has taken trial advocacy so far? Okay, almost all of you. Tell me what the golden rule is, somebody. Never place them in the shoes, right, of the victim or of the defendant, whoever, right? But animations, you get to place them in the shoes of the victim. That's the best part of animations is you place them there. They have to watch how your client saw the entire accident. That's terrifying for a defense attorney. I would be squirming in my seat the entire time it was happening, but it happens all the time. Let's see here. This one. Oh, this is actually in San Francisco. Some of you may recognize the street. This was a defense case that we did. The defendant actually was making a left-hand turn. You're going to see a scooter that comes flying down and hits the vehicle. And he's sued for millions and millions of dollars. Scooter was going 25, but the important part of this animation was that first scene where you actually see from the driver's perspective, he never saw the scooter whatsoever. So how could he avoided the accident? The scooter could have avoided the accident. Oh, come on, clicker. Oh, biomechanical. So dealing with cases where you've got an accident and sometimes the injury itself doesn't make sense. Rob and I had a case not too long ago where a guy had a finger injury, if I remember correctly, and ended up requiring surgery from a motor vehicle accident. We couldn't figure it out. We're like, how did he injure his finger? It was a low-speed crash. How do you injure his finger that required such extensive surgery? This is really where biomechanicals come into play. Usually it requires an expert that is talking about biomechanical issues and how the body moves when forces are impacted, so on and so forth. What we'll do is we'll actually work with these experts in order to recreate what the human body looks like during an accident. And you can see that we can show various portions closer up. We can show the brain actually getting injured, showing a TBI of some sort with a ponytail, of course. Can't forget the ponytail. And we can show the whiplash injury right there. And I'm going to skip through. Construction, a huge one. So this was actually a flooding case that we did where basically there was a bunch of leaks that were throughout a property. What we're able to do, and this is actually compiled through drone, laser scan, a couple of different things. we can zoom in and show the flooding and how it is happening, how it is affecting the various portions of the actual building, right? Anybody that has had a flood in their house knows that is not a fun thing to go through whatsoever. It not only just damages your floor, it goes underneath your house and actually damages the foundation sometimes. This was a multi-million-dollar property that was a construction defect case where essentially they didn't seal it correctly. And so there was leaking from the roof, which eventually fed into each and every one of the floors. Now, for all my DA and PD people, this is the fun one, police shootings. Police shootings are actually a really good one to animate. We can show not only the map showing the start of the incident flying on through, but we can actually show the officer's perspective, which you can imagine before body cam was very, very important, right? When we are dealing with body cam footage, normally I'll do something similar to what that first video was, showing the taxi cab, where we're actually breaking it up piece by piece, so long it is good body cam footage from an officer. If it is, helpful to the plaintiff and I'm representing the defense, then we're going to avoid that like the plague, of course, right? This one's a little bit long, but we can actually show how long the chase was, what happened at various times. And we can interlay, see if it actually gets to it. Maybe it's not going to get to it yet. So this was, if you saw earlier, the laser scan, this is the final creation of that laser scan, essentially. So we went out, laser scanned the property, did some drones, and this was the result of all of it after the fact. Let me skip through real quick just so I can make sure I'm through with time. I know this one's a little bit long. This one was a fun one just because it had a lot of moving parts. This was a very long chase, if you can imagine. The guy was throwing drugs outside the window, trying to conceal the evidence, eventually gets outside of the vehicle, and the officer unfortunately had to shoot him because he thought he had a gun. Granted, at night, hard to tell whether or not somebody has a gun. Let's get to the good part. There we go. He crashes his vehicle into there. Everyone pulls up, ready to go. And you can see he's acting very erratically. This one was very hard to put together just because there was a lot of body movements that were going on. This was all based off of the officer's testimony and some eyewitness testimony that happened. I believe some dash cam footage as well. But the important part that I wanted to show on this is the officer's view. This is critical, especially in this day and age. Every single person, especially in California, expects our officers to have body cams on them at all times. Guess what? Not many rural counties can afford body cams still, right? So when you have an officer that doesn't have a body cam, it raises questions to the jury. I cannot tell you how many times a jury has come back and said, if you had a body cam, maybe I would have believed your cop, right? People these days are usually very distrusting of police, especially of law enforcement and the agency itself. So when you don't have a body cam, they think you hid it or you deleted it just because it was bad for your case. There's a little bit of a mentality of, fake news going on, and I don't really like it, but it is something we have to deal with. So how do you remedy that? You produce an animation showing exactly what happened step by step from the officer's point of view, okay? Medical. This is huge, especially for anybody that is looking into, go ahead. I didn't mention it and I should have, so thank you.
Can you repeat the question, Dustin, for those of us on Zoom?
The question was, who creates these animations? Who creates these animations? So at Cogent Legal, we actually have a team of graphic designers and animators, the whole 9 yards, essentially. They're the ones that are responsible for creating all of these things. I am not a graphic designer whatsoever. I'm an attorney, so I work hand in hand with the graphic designers to try to produce what the attorney wants, essentially, and explain legal issues to the designers because they're computer guys, not lawyers, right? We actually have a specific person that does all of our medical because she has a nurse background and she actually did a little bit of biomechanical training. So she knows how the body moves and everything like that. So when we are talking about medical, there's two kind of different things. First off, we can show an animation going into the body, explaining everything about it, right? So when you have an injury and I say, oh, my client, suffered a C6, C7 disc herniation. Does anybody know what that actually means? You know what that looks like? No, no one on the jury knows what that looks like whatsoever, right? So that's the important part of actually having animations showing the actual injury, explaining kind of the medical jargon behind it and how our body is formed. Because most people will know, okay, yeah, I know what a disc protrusion or a disc bulge is, right? But they don't actually understand the science behind it. And that is critical in cases. Rob can vouch for me on this. Usually the defense will pose a causation element and say, oh, well, your guy had this disc herniation well before the accident, right? Normally the plaintiff has to overcome that. In order to overcome that, they actually have to explain the medical jargon behind it and how the injury happened and show the various portions of the body. Oh, this one's just a very simple graphic, but we can actually take x-rays and make them a little bit better. Everyone's seen an x-ray here, what it looks like. I think I've got a slide here. So you're gonna see this is actually an MRI over here. This is what the MRI looks like. Obviously, we can highlight and show where the vertebrae are all through here, but then we can actually just do a 3D illustration of that lumbar spine, and it looks 10 times better. Makes way more sense. Of course, you're going to have experts that are going to come in and talk about the x-ray and point out various things that are wrong with your client. But having that coloration just makes it pop that much more. So what we do is we take the x-ray, we take the 3D illustration of the lumbar spine, and we add them together. Okay. That way you have the best of both worlds. Your expert can go in and say, oh, if you look at this x-ray, we've got, a little bit of damage right here, whatever. But then you have the coloration showing the actual lumbar spine for the jury so they know exactly where it's at. This was a 3D model we did. So there's kind of two schools of thought. There's the 2D, right? And then there's 3D. Much prefer 3D. It's much more animated. Anyone here knows we are all, I'm assuming every person here has an iPhone or a smartphone of some sort, right? You got Facebook blowing ads at you all day. You are constantly berated by visual information from your cellular device, from your computer, from the billboards outside, right? The jury is the same. They are expecting this. Usually, jurors only have an experience with being on a jury through Law and Order. That's it, right? So they're expecting a show. They're expecting, that smoking gun to come out that time. And frankly, through the use of helpful visuals, that is your smoking gun, okay? Oh, we're finally almost to the end, guys. We made it. Good job. So I'm going to talk a little bit about trial techs. These are folks who basically wish that they were lawyers. But what they do is they run all of the technology in the courtroom. And let me tell you, it is an art with what they do. These folks will usually they have a program. There's a couple of them. There's a trial director, there's trial pad, and then there's OnCue. We at Cogent Legal use OnCue. OnCue, we have found, is way more user-friendly, and also they have a great support staff for when the program crashes, if it does at all. Now, what they will do is they will actually go to the courtroom and they will set up all of the equipment for you. With that, they will make sure that everything is in working order. I'm sure all of you know, as attorneys, we are not only just attorneys, counselors, we are also accountants sometimes. Sometimes we're experts. Sometimes we're medical doctors when we have to cross-examine a doctor, right? We wear a lot of hats. And just taking away one of those hats of using tech in the courtroom or being in charge of the tech necessarily alleviates a lot of problems. When you're in trial, you have so many different things you're doing. You're listening to the witness, you're listening to the judge, you're watching the jury, you're waiting to see if you need to make an objection to a question that's being posed, right? On top of that, you're trying to take notes and listen to your co-counsel about what's going on in the trial and what they think. A lot of things are going on. Alleviating that one little thing of using tech in the courtroom helps solve a lot of problems. This is just a general courtroom setup of what I kind of like to see. Now, this is probably more likely than not, it's probably federal is what I imagine. So you've got council table right here. You're gonna have screens. Any of the blue little slides right there, those are blue squares. Those are actually supposed to be screens. Normally what I recommend is instead of a projector with a screen, I actually say get a large TV, like a 55, 65 inch, to throw in front of the jury. Just better quality, especially if you're going to be doing animation or graphics to the jury. And also jurors will just feel like they're watching TV at home, which makes them feel a little more comfortable. With that, you are going to have your trial tech actually sitting behind you. They are going to have a laptop station with a little switchboard. Normally what happens is you have two trial techs. You have one for the plaintiff and one for the defense. Obviously, if your trial tech is working with you on your presentation, you don't want any conflicts whatsoever. So you have your own separate trial tech that comes with you. A lot of my clients recently have been training paralegals to go ahead and serve as their trial tech, which is good. But they definitely don't have the amount of experience as some of the trial techs that are just contractors going out to various different places. With that, you're going to see over here, we've got a 42-inch monitor that's facing the jury. That is just so that if any jurors can't see this over there, we got an option for them over here. And then if you got the budget, which most people don't, I like to actually put screens inside the jury box. That way it's right in front of them. So when we are throwing up exhibits, it's right in front of them. It's easy to read. Most people probably don't know this. There's a significant amount of our population that are colorblind, and usually it's the colors red that people don't see. So when I said earlier, plaintiffs use red, actually stay away from red, just because sometimes that'll come across as, you know, black or whatever it come across necessarily. And then you can't read the text. If you got red text on a white slide, it doesn't work. Oh, courtrooms do vary. San Francisco has a wonderful courthouse. Some of the courtrooms are a little bit small and a little bit crammed, right? But usually they have a good amount of technology available. I grabbed this one. This one, for some reason to me, I don't think it is Contra Costa, but it looks similar to Contra Costa, some of the Contra Costa courtrooms. You can see how tiny this courtroom is. Imagine doing a trial post-COVID with all these jurors sitting there in the box, nice and close to each other, feeling very, very vulnerable. Terrifying, right? What I want to demonstrate here is some courtrooms, there's not a lot of room for tech. And so being flexible and figuring out things, that is critical. And that's what our trial techs try to do. So normally we'll actually go in, we'll scope the courtroom out, and we'll figure out the best place to show the jury, to show the judge, show the witness, everything. Sometimes it requires a little bit of handiwork. I can tell you right now, I'd probably set up a screen right there for the witness, just right at that table, which would probably cause a tripping hazard for the court, but it does happen, okay? But then you also have these nice, beautiful courtrooms that are usually really well set up for tech. One of the best courtrooms I've been at was, I want to say it was Monterey. Monterey had all the equipment available. We didn't have to order anything whatsoever. Okay, they upgraded their system. This is actually a screenshot from OnCue. So one of the things that trial techs can do, which is very valuable, is they can go ahead and make deposition callouts or depo videos that you're going to play to the jury. There's been a huge trend with the plaintiff's bar recently where they're not calling witnesses. I think it's because of COVID concerns. They want to show respect to the jury. And so instead, they're just playing deposition video clips the entire time. Now, what the tech can do essentially is he's got the entire file all down here. He can designate a certain portion of the testimony. So, you know, it says page 52, line 1 through 13, for instance, right? All he's got to do is type in page 52, line 1 through 13. It's already highlighted right there. And what it does is it makes the depo clip and it actually makes the subtitles right at the bottom as well. Quick, easy, painless, don't have to do anything in terms of being the attorney besides tell them what you want. This is also a screenshot from OnCue. This is a document callout is what we call it. So in the background, you'll see the actual document, and what the trial tech will be able to do is they will actually just put a nice little square and it'll do a pop out showing the actual text. This is super helpful for construction cases, really any case where you've got a whole bunch of documents that you're going to be showing to the jury. Very, very helpful, and even better, you can throw a little highlighting in there. to emphasize your point, I just grabbed a random document and threw this up. So don't judge me for Conan O'Brien over here. About us. So like I said, I work for Cogent Legal. We basically do a whole host of things. We do graphics, 3D design, mock trials, jury selection, evidence preservation. We talked about laser scanning and drones. That would be characterized as evidence preservation. We do the medical imaging and we do the trial tech. And then lastly, I threw my information on there. If anybody wants to reach out to me and wants to learn more about anything that I talked about, I'm more than happy to talk. I hope that all of my fellow GGU soon to be alums all here, that you take this to heart and actually use technology in the courtroom, because it is powerful. It is something that will help develop your case and sell your case to the jury. Even if it's a simple PowerPoint, I have clients that will do PowerPoints that are 99 slides, way too much, especially for opening or closing. Opening, 10 slides. That's all you need. Very simple, very easy, very efficient. Okay. Closing, maybe 20 because you got some jury selection or jury instructions in the verdict form you got to throw in there and walk them through. But using PowerPoint is the first step of actually getting into and doing some higher level stuff. So play with PowerPoint and have fun with it. For those that have Macs, then you've got the higher version of PowerPoint, which is better. But thank you again. If anybody has any questions, Rachel, if you got any questions in the chat there, I am happy to take them.
We do have some in the chat, but let's start with the ones that are live and then we'll switch over to Zoom.
The live gets the first of the draw.
I love the presentation. Thank you, Dustin. I had regarding the admissibility of some of these, because I'm assuming that they're gonna bring their experts. One side and the other one is gonna disagree. How can you talk about like the admissibility of some of these things, because they look great, but even sometimes a little too good?
We walked a very fine line with this, I will say. Normally, a lot of the animations, graphics that we do, they are purely for demonstrative purposes, right? So they're not going to go into evidence. There's no admissibility issue there. It is just to demonstrate something to the jury. That's your first workaround. I have had a client, I still to this day don't know exactly how he did it, but he had an entire PowerPoint that he used in opening that had a timeline element with document callouts throughout it, kind of similar to what we saw earlier. Somehow he got that admitted into evidence, and it was full of attorney argument. I still have no idea how he did it. It's possible to get these things admitted, especially if it's helpful to the jury. Normally what we have is we have an expert that's going to testify as to what it is, right? So he's going to explain, oh, well, I worked with this graphic designer and, you know, I took this medical imaging and I'm showing X, Y, and Z the entire time. And that's one way that you can get it admitted. In terms of PowerPoints that you're using for opening or closing, you're not going to admit those. Those are just, you know, demonstratives that you're going to be using throughout the trial. No problem. Any other questions? Yes. Let me walk it over to you so all of our viewers can hear, or I can repeat it.
My question is about confidentiality, because the plaintiff, defendant, whoever gives you all this information, and then you have to share it with the tech person who's going to create these. How does that work with confidentiality?
So when we take on a case at Cogent Legal, normally we have a letter of engagement that includes a confidentiality clause. So it is all confidential. I'm not going to call the other side and say, hey, by the way, we're making this sweet graphic that it's going to kill you guys in trial, right? Absolutely not. We don't talk to the other side. The only person that we have contact with is the attorney that we're working for generally, sometimes the client, sometimes the experts. The reality, though, is that in terms of what you're going to present at trial, that's not going to be confidential. That's going to be disclosed eventually, right? When we do receive, you know, confidential information such as medical records or, you know, a summary from the client himself that he wrote for his attorney, right? That stays with us. We're not going to be sharing that information whatsoever. We don't have an attorney-client relationship necessarily, but we are bound by confidentiality through our contracts. Great
So
question.
Dustin, real quick, is that, for you, how you're saying, oh, the defense made a graphic on the health issues of the plaintiff that they might have had pre-existing issues or medical issues. So are you talking about there's still confidentiality with that when you're using the other side's information in your own graphic to prove something for the opposing counsel?
Trying to follow your question. So you're
Yeah.
saying if I
So say your
if I'm-
defense, say your
Yep.
defense, and you're trying to show maybe the plaintiff already had pre-existing conditions.
Sure.
And this, this accident didn't cause all the injuries they have. So you're
Sure.
using all the medical information from the other side. Is that still a confidentiality issue?
No, not necessarily, because that those records have been produced. When you file a lawsuit, then you have actually a limited privacy right that goes with your medical records because you are making the claim. The defense has an opportunity to go ahead and try to defeat that claim. So when information comes to us, we just use it properly and don't disclose it to anybody else besides people in our company. Does that answer your
Great.
question, Rachel?
Yeah, definitely. Thank you.
Any other questions from my live audience before we go to my virtual audience?
The in-person, everyone's live, but yes, in-person audience.
I guess that's true.
So I got a couple questions here online. So we had a question that says, how does a video simulation, the leg and the bone hitting the pavement with the guy getting hit by the car? They had that question at that time where it says, how does a video simulation of an injury like this get through evidence rules like hearsay or other types of objectionable things? The objection would be that the video editor is not a medical expert. How do you get around that?
Oh, absolutely. So we've actually had to, in the past, we've had to testify as to how we created these videos before. It's very boring. Normally, we're just like spilling a lot of nonsense that attorneys don't understand whatsoever. We're like, oh yeah, we just bring it into this program and we add these layers, and they're very confused usually. But normally, if you are going to be using a video or a animation showing an accident, you're going to be using it with an expert. And what we do is we will work with that expert, explaining to them step by step what we are doing to interlay everything so that that expert can usually testify generally as to what was done, where the factual information comes from, laying the foundation right there. And usually it's not hearsay because you're just showing or depicting something. Again, fall back on, Your Honor, I'm not going to be admitting this to evidence. This is just for demonstrative purposes. Right? But I'm going to play it 500 times in front of the jury.
And so when you have something like the police car chase, for example, are you asking the officer on the stand while you're playing that and pausing it once in a while and saying, is this what it looked like to you? Is it a fair and accurate depiction of what was happening at the time? You're asking those questions. I'm seeing a lot of nodding. So it sounds like
Absolutely.
You're getting confirmation from the witness.
Absolutely. Yeah. So
Okay.
normally it varies case by case, obviously, but normally we will take, one witness's account of it. Animations are very expensive to create because they take a lot of hours, if you can imagine. I mean, if anybody has seen a Disney film and saw all the animations that go into that, wow, insane. Okay. What we do is very specialized. It's very technical. And so what we'll take one witness's account of it, and then we will show that witness's point of view. That way, when you have the witness on the stand, you say, oh, is this an accurate depiction of what you saw on that? Or is this an accurate, recreation of what you saw on that night? Okay. We've done animations in the past where we actually have every single witness's point of view or what they saw to show inconsistencies or to show consistencies in the past. Very expensive because that's a lot of work to do, but it is helpful for the jury to understand visualizing where that person was at that given moment. I got a question from my live audience, which I know you're going to tell me is not a live audience.
You're in person audience.
In-person audience. Oh. Thank you.
So my question is just to follow up on that. It sounds like when you have animations or types of visuals like that, it sounds like you're going to kind of would be just like introducing a visual exhibit, like a photograph, and maybe just show a short segment of it, get the witness to testify about whether it's accurate, and then move on to the next segment. Okay, so that makes sense. Thank you.
And I'll follow up on that. A lot of the attorneys that we deal with, they will usually show these animations during opening or closing, and that way they don't have to worry about it whatsoever. If it's shown during the trial, then it is shown through an expert or it's shown through an eyewitness, somebody that has personal knowledge so that they can lay the foundation for the animation. Easiest way, experts. That's the easiest way, right? I've got an accident reconstruction who goes out there, he does all of the workup, he does all of the drone scanning and all of the recreation. We do the animation for him, right, or her. And then he gets up there and he testifies as to all the data points he collected and he or she collected and how the animation came about. Usually comes from us in terms of authenticity and laying a foundation there. But like I said, very boring. We're just like, we made a bad video better. That's what we did.
We've got a few more questions. I know it's right at 6 o'clock here, so we'll hustle through these last few questions here, and then we have a couple raffles, quick raffles that'll happen. Do you prepare presentations for pre-litigation matters so that someone like a plaintiff's counsel might be able to get a quick early resolution?
Excellent, excellent question. Yes, and I highly recommend them, especially for the plaintiff side, because you've got to prove your case up before you get to mediation. Defense side, usually they wait until the trial is knocking on the door before they actually start spending a crazy amount of money. We do a lot of settlement videos, day in the life videos, for instance, showing a client's injury and how they are affected daily by said injury. We will also do, we just recently did a mandatory mediation, which is essentially an arbitration from what I understand, but it's called a mandatory mediation for some reason. It was involving a mudslide that took out this entire retreat that was multi-million-dollar retreat. And so we were actually showing a map of the property and how they wanted to rebuild the various portions of the property and the cost associated with that. And it was interactive, so you could click into the various things to show what the vision was and what they wanted. They ended up showing that to the mediator, and the mediator was like, hey, if you guys don't pay up, how are they going to make this pretty little diagram over here that we just saw? So they settled for a lot of money. It's very, very efficient, very helpful. I am a firm believer that in order to make money on a case, you got to spend a little money.
Sounds like you're a gambler, Dustin.
I'm very much a gambler. All trial attorneys are gamblers.
I think so, right? I think so. But the next question on here is somebody said they watched the animation in the Gwyneth Paltrow case for the skiing accident. They said it was a great animation, but too fast. And it seemed as if the trial tech didn't work with the attorney beforehand. How does Cogent Legal work with their attorneys to make the animations the best possible?
Absolutely. So this very much depends on if you have a trial tech in the courtroom. If you have a trial tech that is from Cogent Legal, we will make sure that they are working with you outside of the courtroom to perfect your presentation the entire way. Majority of our trial techs are, I wouldn't say necessarily graphic designers, but they are proficient in PowerPoint, so they can actually create slides for you on the fly during the trial. No problem. That's okay.
Oh, go ahead.
And going back to that, it's important for a graphic designer or an animator to actually understand the audience that they're presenting to, how it's going to be presented, and slowing it down is something that is very easily done. I imagine that the team in the Gwyneth Paltrow trial just didn't know how fast it actually was and didn't actually practice before they showed it, is what I imagine.
So one question that came up sort of relating to what you're saying on trial techs, have you ever had trial techs assist the jury during deliberations if they want to see something played, or are they prohibited like counsel is?
If it's allowed by the court, yes. So we have occasionally had a trial tech come in to the jury deliberation. Normally, especially now that technology is becoming more up to date in the courts, normally what we're finding is that courts are actually using some sort of a share file system for all the digital exhibits. Alternatively, they will use just USB sticks and they will stick it into whatever the computer is in the actual jury deliberation room. So the jury has access to it. We have had situations in the past where the jury said, oh, I want to see, the depo video that we saw from this witness. And our trial tech will come back and actually play it, but it is only if the court allows so.
How do you get the jury to trust that your representation is accurate and unbiased? Because they could see how a juror might be skeptical of a recreation since it's prepared for a certain side.
Yeah, and this actually, I think, goes to more so the presentation style of the attorney. The goal of an attorney just generally in trial is to build credibility with the jury. It's not just enough to have a witness be credible, right? You as the attorney have to be credible to the jury. And that starts with voir dire, opening statement, all the way through trial. Jurors generally, I will say, hate obstructionists. They don't like it when you have a lot of objections and you're slowing down the trial. They hate it when you're disorganized, for instance. You can lose credibility really quickly there. The big thing that I've seen attorneys lose credibility over is opening statements, over promising to the jury that they're going to sell them something and then not delivering throughout the trial. That is a huge thing. And just to piggyback off that, I would say, make sure that you are not telling the jury what to think. You are explaining to them. There's a significant difference. Jurors, especially millennial jurors, they do not want to hear you telling them facts. So I can't get up there and say, the defendant was negligent and you're going to see, blah, blah, blah. Instead, I'm going to talk about, oh, well, there was this rule that the company had. And when the company instituted this rule, I'm going to explain why that rule is important, right? That putting the two together, here's the rule and here's the explanation, the policy reason why that rule applies, that helps the jury understand. And then they actually buy into what you're selling rather than me just saying, you're going to hear that there's this rule and the company didn't follow it. That doesn't do anything for anybody. Jurors want to understand and they want to have things explained to them, not told to them. So build your credibility throughout your case is what I say.
So Dustin, I've got two quick last questions, then we'll do the raffles and get folks out of there because I know some folks have classes and other meetings and such. One of the last two questions was, have you seen there be a lot of opposition from the other side with interactive exhibits or on-demand deposition references when opposing counsel doesn't get a full chance to review something or they don't think they've had enough time to review it?
Absolutely. When I'm saying that people are doing these kind of depot cuts on the fly, it's true in some aspect. Normally, for instance, with depot cuts from a trial tech, you're going to have designations that are going to go beforehand. Unfortunately, Rob and I on our last trial had designations given to us, I think like 2 days before the trial started. And it was a lot of designations that we had to course through. There were a lot of objections we had to work through with the judge. Normally, attorneys always say there's no surprises at trial. Everything is disclosed generally. I'm going to show my PowerPoint to the other side, right? We've got an issue in California specifically with Sanchez violations in terms of what an expert can testify to and what they can't testify to. That does interplay with graphics. I have defeated that objection a couple of times very carefully because what we will say is, oh, there's no new opinion by the expert. This is just demonstrating the expert's opinion in a more succinct way. And I actually had some success on getting things shown to the jury through that.
Okay,
Hopefully
well,
that answers the question.
yeah, I think so. So Dustin, thank you so much. We really appreciate you giving us your time and sharing such interesting ways to use technology in the courtroom. I'm a visual person, so this was really helpful. I love seeing things as they might have actually been on the day of the incident. So I'm sure Dustin will stay after a little bit for folks who might have additional questions, and those in the Zoom. If you didn't get your question answered, we will forward them to the speaker and he can answer them to you by email. Really quick, what I think Greg's going to do, if he's there, is what I'd like you to do, Greg, is we have 9 people on Zoom. So if you can give each person in the room who's an audience member a number starting with 10, and then we'll do the raffle that way.
Okay, got it. All right, so 10, 11, 12, 13, 14. All right. I
So we got
actually have
14
5
total.
Yeah, I have 5 prizes here. So
Oh, okay. Okay. So I have a random number generator here. So I'm going to put 14 in because that's the total amount of people we have. So the first number that came up is 3. So let's see, third, it would be on the Zoom here. So I've got Hannah, is that Hannah Cooper? I'm guessing. I'm going to go with probably yes, because I invited her to this event. So Hannah, you're going to get the first prize, which is
A lanyard.
a GGU lanyard. So you're going to get that. You can use it for keys, a badge, whatever you want for that. Okay, the next one I have generated on here is number 12. So who was number 12 in the audience?
Oh, okay. No, that's you, Neri. Yeah, we went this way.
All right, Neri. What's Neri getting?
He has the second of 3 lanyards. These are in ascending order of worthiness. So one
So
more
I
lanyard
think
and
the
then-
surprise is out that the third prize is probably going to be a lanyard. Okay, let me check this number generator. Number 8. So I think that would be on my side here. We've got Steve D. I'm guessing that's Steve Downs. Also another invite here from the introduction litigation course. So Steve, you're getting a GGU lanyard. So when I see you, I'll give those to you. And then we have 2 more, you said, Greg?
Yeah, this next award is a Golden Gate University beanie. Very nice beanie.
Okay, this number is number 14. So whoever was the last, you're not least, you're getting a prize.
Oh, there you go. Congrats. You have anything to say?
Thank you for the beanie.
Is that Tom?
And finally, we have a very nice, it's like a leather holder for a legal pad with a legal pad inside of it. So,
Oh, like a
there you go.
portfolio, like a portfolio.
yeah.
Okay,
One too
is-
soon.
Greg's like, yes, a portfolio. Okay, so let me see what we have. I said on my random number generator, I had 4. So let me see, we're on 4. Naz or Avani, you're getting the portfolio.
Alrighty.
Okay, so,
Congratulations.
so luckily those are students, most of those people. Was that Tom with the beanie? Was it? Is that
Yeah.
yes? Okay, I'm just writing it down so I know who we have getting everything. So we have Hannah with a lanyard, Neri with a lanyard, Steve with a lanyard, Tom with a beanie, Naz with a portfolio. So we're gonna close out the Zoom room now, but folks, like I said, if your question didn't get answered, I'll send those to the speaker, he'll email them to you. But thank you so much for your time today, and we hope you go out and try to stay dry tonight, and see you at the next litigation event.
Thank you, Dustin.